Well, we're going to call to order this hearing of the Board of Appeals on the H&W apartment application on Randolph Avenue seeking a comprehensive permit. This is the July 16th, 2015 hearing at 7:30 in the Blue Conference Room. My name is John Leonard. I'm Chairman of the Board of Appeals. With me this evening, to my immediate right is Board Member Virginia Donahue King, and to my immediate left is Board Member Jeffrey Mullen. We met on, I believe it was the 13th of July, and at which time we had our first deliberation session, and we had a wide-ranging discussion of all of the various issues. We suspended the hearing at that date to tonight in order to allow the board members to review their notes, the records, the materials submitted by the applicants, and perhaps firm up their opinions on this particular application. So with all of that having been said, Mr. Mullen, do you want to be heard first on where you stand on these deliberations?
Did we talk about how long these units would remain affordable?
Sure. Yes.
Did we?
Did we? No, I don't think we did.
Should we?
I think you probably should, but just fire away. You just put your views out there.
I was thinking that these would be permanently affordable.
Yes.
I think the application contemplated that, doesn't it?
Yes, they do, and it is a condition in the permit that the properties would be permanently affordable. 25% of the units would be permanently affordable. There would be a regulatory agreement that would be done with the financing agency, MHP. And then when that expires, because of the date and also because of the completion of the financing program, the town would have its own regulatory agreement that would maintain the affordability.
Fine. Does that
Yeah,
answer your
thank
question,
you.
Jeffrey?
Yeah. I looked at the
Could you keep your voice up? Just
I looked at the substitute application that came in from Reamer and Bronstein, Robert Buckley, on behalf of Joseph R. Mullins of 300 Highland Street. That application called for 35 units, as I counted them. It was
the submittal. You said application.
I'm
You mean
sorry.
the submittal.
Submittal.
Sure.
So we talked about that, and I couldn't recall from Monday whether we talked about 35 units or 40 units in terms of the density, and I was looking for a reason for a particular number of units, and this submittal provides that. I wonder if we might not talk about particular conditions at this point. I think in the interest of getting some affordable housing in the town, I think it's a reasonable approach, John. And I wasn't contemplating that on Monday, but I think with appropriate conditions, the issues that I spoke about, which I was concerned in the conversation on Monday about the site access and the traffic and the local concern, as the regs say, I think might be able to be addressed, particularly if we were to focus on the density and the access issues. So I'd like to do that. I'd like to suggest we do that. I don't know how to do that, but.
Well, let me suggest one thing. The reason that the 40-unit figure came up was contained in Attorney Karen Schneider. I keep calling her Karen. It's terrible. I really apologize to Attorney Schneider. In another life, I must have known a Karen. But Johanna Schneider of Brackerman, Surrey and Brewster, and she indicated in her submittals that on behalf of the Carlin and the Lombardi families, that she thought 40 units was the appropriate figure, but she did not submit any sketches or preliminary plans showing a number of units in each building or the types of buildings and that type of thing.
Right. Okay.
Okay, so with that having been clarified to some extent, Mrs. King, do you want to be heard?
I think that we can probably craft something together to address the concerns that we have about the density, which renders a lot of some of the other, not all, but some of the other issues to be non-issues. And I think that that would be probably the best way of using our time tonight.
Okay.
I agree.
So do you want to reach a preliminary agreement on a number of units, Mr. Mullen, or you just prefer to talk about conditions and then deal with the number of units on the density issue?
Whatever your pleasure is.
Well, I don't think it makes any difference. 35 units, 40 units doesn't make a lot of difference. It's a significant deviation from what the applicant applied for. But as I said last time, I don't think the applicant has given us any options here, which disappoints me.
Mr. Chairman, may I be heard very briefly on that point?
I don't think so. I don't really. Mr. Mullen, you want to?
I don't.
We're in deliberations, and I'm just not sure whether it's appropriate.
I'd
for
be
you.
fine with the chair.
You would?
permitting.
Mrs. King?
I think that we're beyond we are in deliberations and beyond the evidence right now.
Yeah, I think we are too, Nick. And
No by objection for the record to
Oh, sure.
the course that you're now taking and the significant reduction in the number of units.
Sure, of course, we expected that, and there's nothing new about that. I think the problem has been, we don't want to get involved in negotiating units with the developer. Maybe your client feels that we're somehow greatly influenced or controlled by the Board of Selectmen. But we have intentionally stayed out of the issue of any negotiations with the town for the reason that we're the fact finder here. And the process, as I understand it, if the town wants to negotiate or you want to negotiate, you can. Bill Clark, the town planner, is available or was available to negotiate a lesser number of units. And unfortunately, for whatever reason, those negotiations, if there were negotiations, I think there may have been some preliminary negotiations, got you nowhere. Apparently, in your opinion, the town may disagree with that. Nothing from my view of this, and you have the perfect right to object and to challenge our feelings and findings, but from my perspective here, the Holland companies had the perfect right to come before the board and say, well, you know, if you really think that 90 units is excessive here, we don't, but if you do, you know, we think that 72 units, or 68 units, or 65 units would be alternatively acceptable, and to present that type of proposal, and we would have entertained it. We're not appointed by the Board of Selectmen, as you probably know. We're appointed by the town moderator. Katie Conlon, who was here at the last hearing, I have to confess, I'll say it publicly, Katie's
In
here
the current
tonight.
meeting.
I know Katie from some legal experiences, but I really don't know the other two selectmen. Don't know them. I've never talked with them. I've never met them. I may not recognize them. They came into the room. They haven't communicated with me. So, you know, we really feature ourselves, maybe wrongly, but I think rightly, as being truly an independent board here, making an independent decision on behalf of the town. And if the town had said, well, we want 50 units or 45 units or some number, and you said we can't do that, we have to get 68 units to make this financially feasible, we would have entertained that. But I think since we stayed out of that aspect of it, and I think rightfully so, you wouldn't want the town, the Board of Appeals, getting involved in direct negotiations like that. My concern, and I don't mean it's a criticism, but it's just where I find myself, is that I find myself trying to make a decision here based on the evidence presented and not based upon external negotiations that failed or personality disputes with the town or whatever it is. And I am apprehensive. Why I'm talking about 35 or 40 units is we've got some evidence there. If I had some evidence that 50 units may be permissible or maybe financially feasible, maybe I'd give that consideration. But that's speculating. That's guesswork on my behalf. I don't do these projects. So that's the unfortunate circumstance I think we're in. And I'm not blaming anybody. I'm not blaming the town. I'm not blaming Mr. Holland. We're just left with the application as it's proposed. Now,
With all due respect,
Sure.
Mr. Chairman, I don't think there is one iota of evidence about the economics of what a project of 35, 40, or 45 units
well, you
would
can,
be to the
now,
applicant.
you can argue that. All I can tell you is we have Joseph Mullins, who was a developer for 50 years with Corcoran, Mullins, and Jennison. He had plans prepared. He has pro forma, he had a schedule, a draft location plan for buildings. He has conceptual plans for the buildings. He has some plans for the interior. All I'm saying to you is,
This project is not before the board, though.
it's not before the board, and I'm not going to debate this with you, okay? But I'm going to tell you that we're not voting on a project of Joseph Mullins. There's no application before us on that. But what we do have is we have evidence from Mr. Mullins, whether you disagree with it, or you believe it's not entitled to any weight or consideration. You can argue that to a fare thee well before the Housing Appeals Committee, before the Superior Court, before the Appeals Court, before the Supreme Judicial Court. That's your perfect legal right to do so. But from my perspective here, I believe in deliberations with this board that Mr. Mullins has presented evidence, credible evidence, that a 30 to 35 unit development on this site, more consistent with a village concept than a project in South Boston or East Boston, is financially feasible. And I can consider that. Can I say I don't believe it's so? Sure. Can I say I wish he had presented more evidence on that point? I think it would have been helpful to the board, but he didn't do it. I can't compel him to do it. But all I'm saying is on the evidence that we have, 35 or 40 units, he says is feasible. And to me, from my personal perspective, and as chairman of the Board of Appeals, but I'm not a builder, I couldn't build my own garage, but I'm trying to weigh the evidence fairly. If 92 units, in my view, is extreme, if 72 units has to be financially feasible, or they wouldn't have, the applicant wouldn't have proposed it, my guess is that a limited number of units, like 35 or 40, would necessarily have to be financially feasible. It may turn out not to be. You can challenge that. But I'll tell you, you'll challenge that with Mr. Mullins and all of his engineers from Corcoran's, Mullen, and Jennison before the Housing Appeals Committee. They can decide it any way they want. But to me, there's sufficient evidence, credible evidence in this record to find that 30 or 40 units would be feasible. I'd love to see where the other alternatives were, but we don't have them. We don't have them. And I'm not blaming anybody for it. But if I say, well, let's do 60 units, everyone's going to say, oh, you're flipping coins. You're making averages. There's just no evidence of 60 units or 50 units. And I wish there were one way or the other. So with that having been said, and I appreciate your comments, and I don't really mean to shut you off. We know.
Our objection is noted. Thank
Yeah, it is objective. It is, and obviously, if we're not going to grant you 90 units, we expect your vociferous objections, because obviously you think that's the proper density for the site, and we just don't think it is. And then you have your remedies, and we'll do our job, and we'll see where this goes. But with that having been, Mr. Mullen, let me ask you, do you have any comments on this little colloquy, or
No.
you content?
Good.
Mrs. Fitzgerald, Mrs. Virginia.
Other than,
okay.
Oh, I concur with all you've said, yes.
Okay, Jeffrey?
no, I
No.
just,
Okay, so if we're going to do and grant a comprehensive permit for some number of units approximating 35 or 40, then I think it's appropriate to discuss the specific conditions. And I think, as Virginia said, and as Ms. Schneider has said, if you drop the number of units significantly, a lot of the problems that we have with the 90 unit proposal tends to be ameliorated. So do you want to discuss specific conditions, Mr. Mullen?
let me ask you.
Sure.
So when you're thinking about conditions, this is the first time we've been through this, right?
Yes, it is.
Would each condition be qualified by a reason for the condition? Or,
I could speak to that a bit. It might provide you with some assistance. I did a draft to sort of show you what the decisions typically look like, and I provided that at the last meeting. I have a revised draft today, assuming that you're going to reduce the number of units, and with conditions that reflect the changed project. And I have copies of that here.
Okay, do you have a copy for Mr. Cram?
Yeah. There you go. That's why I was late.
so I,
So what I was speaking to, Mr. Mullen, is that the decision breaks down in several categories. There's a procedural history, which would have a list of everything that's been submitted, the dates, everything we had hearings. The jurisdictional requirements is the next section, which talks about whether or not the applicant is qualified to apply for a 40B permit, which we believe he has, that it's a fundable project, that he's demonstrated site control. The part that you're referring to are the findings. And the findings are the board's review of all of the materials and taking a look at the application that was filed. And that sort of backs up the conditions that would then be. So if you see, starting on page 3 of the draft that I just handed out, are findings. And, you know, first of all, do we have enough affordable housing in Milton? And we don't. Where it goes on to on page 4 is really talking about this project itself. And in number 5 on page 4, I took up the issues that we had last time about the sustainable development scorecard and the fact that, you know, the applicant said that, you know, the density is 15 units, but actually it's 27, that the answers on that sustainable development scorecard were, you know, in many cases incorrect or misleading. The site's not pedestrian friendly. It's, you know, the building is huge, one of them, and there's only one elevator at one end, so that doesn't really help very much for handicapped residents. And those sorts of things that you mentioned at the last hearing. And those findings sort of finish up on page 5, and then you make the decision as to what, this one assumes that you would do 40 units. And then following on page 5 are all the conditions that I've imposed, sort of discussed about imposing to address the project. Basically, the difficulty is that since we don't have plans for what a smaller project might be, the applicant had asked for a waiver of site plan review, so I didn't grant that waiver because I figured they're going to have to come back with a different set of plans showing what they might want to do. But I tried to, in the conditions that I developed, sort of say, well, they're going to submit architectural plans, you know, the mechanicals are going to be hidden, the design is going to ensure that no dwelling units more than 100 feet from an elevator, and that the design would reflect, let's say, the surrounding neighborhood, which is a mix of single-family colonials, Victorians, mid-century split levels, and that sort of thing. So that there was some sort of hint that we'd be looking for something a little different than what this had been proposed. And then it goes on to do the open space and landscaping. As Mr. Leonard mentioned, Johanna Schneider made the very good comment that if there are fewer units, then you don't need a 15-foot high retaining wall, and you don't need all these dead ends and that sort of thing. So we tried to I put together sort of basic conditions that sort of would allow for a looped circulation through, you know, around buildings, so there's no dead ends, there's no backing the fire truck down the slope. I did put in something about a left-hand turning lane, and that would, at some points in the day, be also useful for pickup and delivery of school children. It sort of gives you a general kind of hint about the kinds of things that I put in to address the concerns that were in the findings.
Okay, great, this has it's very helpful. Let me ask you, Mr. Cram, while you're there and still awake, does the applicant seek to submit a similar?
We haven't prepared one for.
No, I know you haven't tonight. The only thing I'm concerned about is I want I want you to have, this is the first time I've seen this here. And,
Same for us.
yeah, and I want to be able to review it
It's really hot off the presses, I
in
have
some
to say.
detail.
And if I hadn't lost it somewhere around 5 o'clock where it disappeared on the computer, I would have emailed it to everybody, but.
So what I think I'd like to do is,
We just reserve the right to comment on it and supply our own response.
sure, here's the problem I have, and you know the time schedule better than I do here. We'll discuss, Ms. with it,
McDonald.
yeah, this particular document and the proposed conditions, but I really think that if you assume, though you may not like it, that the decision of the board is going to be 35, 40, something like that, units, and you want to submit your version of this, it doesn't have to be as comprehensive as this. I think you should have an opportunity to do so. If you don't want to do so, that's perfectly fine as well. But if we discuss this tonight and if we vote, we really can't vote on this. And I think in fairness, if you want an opportunity to comment on some of these conditions or some of these findings, but we certainly can discuss it tonight. My proposal would be that we not vote the decision this evening, that you'll be given an opportunity to be heard if you want to do it. And then the clock won't be ticking, because there's no sense of you submitting anything if we make a vote tonight, and we vote on conditions that you haven't had an opportunity to refer to.
Thank you.
On the other hand, you may prefer not to do that. It's entirely up to you, whatever you want.
It's a substantial document, so we certainly appreciate the opportunity to review it.
Okay.
I don't know what our response, if any, will be.
Yeah, I think the difficulty we're going to find here is that, according to my calculations, we have to, unless extended, we have to decide this case by the 29th. And then the clock really starts ticking. And I think we have 14 days to crank out a decision and get it recorded. Today's the 16th.
Filed with the clerk, yeah.
So it has to, do you think you'd be able to give us your effort sometime that's 3 or 4 or 5 days before the 29th? Or if that's really an issue, and I'll give you as much time as you need. I'm not sure we can even extend the 29th date.
With
We
their
extend that by
assent.
agreement.
Yeah.
That's
They'd have
the
to
other
agree.
possibility. If you, for example, if Mr. Caggiano or you have vacation plans or whatever you have going, and this would put you into a pickle, you know, if we extended the 29th date by a week or something, I have no problem with that either. I just want to work out what's fair for you, or what's the preferred way of going.
I do have a date set aside for Monday.
That's not good. That's not
I know, but I'm just,
I don't think we need extra time
Okay,
on our end.
all right.
Thank you.
So, Mr. Mullen, are you
Yeah.
content to go over this document with respect to specific conditions?
I'm happy to, but I have to say, John, this has so much detail that we just don't know. Like 25% of the units have to be affordable. I have no idea.
That's the law.
Okay, good, then it should say it's got to comply with the law.
Well, we can do that. This is a
I'm
draft.
just saying,
Yeah.
that this is full of detail, and what I'd rather do and what I tried to do in the conditions that I spent, a lot of time on between today and Monday, and spent a lot of time on this application, just be much more general, and because I don't have any basis to make some of these findings is the concern I have in general.
Okay,
So
all right.
I don't know if we should work off this or not. I will say in past cases where we've had detailed conditions, we've had the conditions and we've worked through them in person, and it's a little bit easier. But so this is, we got multiple things going on here.
Well, do you want to work off of a set of conditions that I can adapt into some type of a
Yeah.
decision here?
Yeah. I was just thinking about the conditions, that's all, not so much But for example, the project shall be constructed in conformance with the site and architectural plans to be submitted for site plan review in accordance with this decision. Does that mean that we're issuing a decision and we're calling for site plans? I mean, or is there going to be a subsequent application submitted? I'm not sure of the procedural posture here.
Well, I can't tell you I am
No?
as well, but I think this. We're not imposing Mr. Mullen's site plan or his
Yeah.
architecture or his placement of buildings or anything like that on the applicant. But if we do vote a comprehensive permit for, let's say, 40 units, then, and we try to suggest to the applicant that we're looking for some village-style development as opposed to 40 units in one big brick building that looks like it was in Kremlin Square or Red Square. I presume if we're not reversed by either the Housing Appeals Committee, the Superior Court, or the Supreme Judicial Court of Massachusetts, that if the applicant has a comprehensive permit for 40 units, he's going to have to be filing some amendments to the plan.
Right, I mean, that was the difficulty, I mean, thinking about what you would do as a draft, it was like, well, just deny the 90 and say that's it, you know, which was one possibility. Just, here's the findings, no conditions, because it's outright denial. And they appeal to HAC, and then HAC, you know, whatever, sends it back down, and we have the discussion all over again. So that's one way to go, is to say, okay, fine, we saw this application, we saw all these materials, we're voting yes or no, period, on the 90 units. Second option is to say, as Mr. Leonard had suggested, and I think Virginia, you had too, Ms. Dunn, it said, well, we would approve some affordable housing on the site. And the, talking to the selectmen, and to the planning member, Alex Whiteside, they suggested that perhaps that would be a better way to do it, would be to modify the application to issue a decision that was fewer units. But the problem with that is, as Mr. Mullen pointed out, we don't have any plans for fewer units. So that sort of puts
Right,
us
but
back.
there's no
in a
doubt that 40
situation to
units
say-
can be built there, or 35 units can be
Exactly.
built there.
So then it's going to be sort of, if the applicant chooses or HAC decides that, yes, they would approve this, they would uphold our decision, then the applicant's going to have to come back and submit different plans. Because right
Right.
now, what we've got are 2 buildings that contain 90 units.
That's right. Or the applicant could say,
So-
well, to heck with this project, I'm not going to do it, and I'm going to sell it to a shopping center developer. I'm going to
Yeah.
do whatever you want. There's no requirement that you have to build 35 or 40 units.
Right.
Even if Housing Appeals Committee says it's financially feasible.
Right.
But see, that's not our function to get
Right,
involved in.
so there's a little squishiness, I have to say, as Mr. Mullen pointed out, because I can't say you gotta build it in accordance with the plans, because we don't have any. That's normally what you would be saying in your condition is, you submitted these plans, and you're stuck with that. You have to build what you submitted to the ZBA. And the building commissioner gets to look that over and say, oh, yeah, right, it's, you know, what you're building is in fact what matches what you submitted to the ZBA. We don't have that situation here, because we don't have a different set of plans.
Right. Mr. Mullen, did you want to
Let me
say something?
just tell you maybe how I approach this and
Okay.
the way I don't think we're modifying the application. I think we're considering approving the permit application with conditions with respect to height, site plan, size, shape, or building materials as set forth in the reg, right?
And density.
We talked, and density, is it height, site plan, size, shape, or building materials that address matters of local concern.
I agree.
So,
I agree with that.
So that's kind of that's where we're at, we are. We talked about local concern, we talked about consistent with local needs, we talked about the concerns that each of us have. So let me just give you an idea of the type of condition that I was thinking about. To reduce impacts to environmentally sensitive lands and natural resources, wetlands and wetland resource areas, mitigate traffic impacts, address public safety issues and concerns on and off the site, maximize retention of open space, eliminate the need for conflicts between pedestrians and drivers, and improve the overall functionality of the layout of the site. The total number of units in the project should be reduced to 35. An appropriate number of units shall be affordable, consistent with applicable law. That would be like the first condition. That's the kind of condition that I think we're talking about, but it also speaks to the concerns that we have. I mean, anybody who thinks we don't have a massive problem on Randolph Avenue just isn't being real. And so, and that's, and to say nothing of compliance with the fire code. So that I think is starting to address them. And I also think it speaks to the local concerns about which we spoke last time: open space, safety, and the like. Promoting better site and building design. I'm trying to work with the regulation and what I understand is our mandate. But then I'd have a second condition to protect the health and safety of the occupants of the project and of Milton, and to protect the natural environment, to promote better site and building design in relation to the surroundings and municipal and regional planning, and to preserve open space. The applicant shall submit site plans to the board for further approval. I mean, that makes sense to me. But because to the council's point, I don't know how else to do it. But I don't want to modify their plans. I just think we want to seek a further submittal.
I agree.
Yeah.
We're not
Yeah.
competent to modify
Yeah.
their plans.
Yeah.
I'm not competent to design a driveway for a 90-unit project or a 35-unit
I know,
project.
that's true. That's very true.
So I don't disagree with your concept
Okay.
of being.
So those are two
Somewhat.
conditions that I would put out there, and I've got a few more, but that was the type of thing I was thinking about.
Well, I agree with that format, but where do you go from there? Do you get specific with respect to whether you need a grand boulevard driveway, as was suggested?
I think the access road is all about approval from the fire department, because I think it's a fire access road, and I don't think it complies with the requirements of the National Fire Prevention Association, and it needs to. And I think the condition getting the approval of the fire department on access to the site makes sense to me. I don't know whether it needs to be a boulevard, because I don't know what the traffic volume would be for a 35-unit development or for a 40-unit development. So on that, I would say,
But you certainly wouldn't need the type of access road that you would for a 92-unit.
yeah, I think that's probably right. I mean, there have been people who've talked about this dual access, and if you don't have the dual access, you need the boulevard. And then there's additional problem with the school bus issue of, and you see this all over the place, where people wait with their children for the school bus, even if it's on site, and then where are those people going to be, given the width? I mean, that was part of why I was asking about stealing some land from 7-Eleven, because I think you need to expand the mouth of that driveway, even if you don't carry it all the way up the hill.
Right.
And I still don't understand why that didn't happen, given the fact that you've got the frontage. Despite the testimony, I'm certain you've got 75 feet of frontage there. So,
But that's a condition that we can impose.
Yeah.
That's a reasonable condition.
Yeah.
Because you can't expect school children to be standing.
yeah, it would do that. Yeah, it would provide for that extra stacking lane. So on that, I'm suggesting on the site access, to alleviate the risk to public safety resulting from the provision of a single means of access, the access road through the site, including its width and a combination of need for fire apparatus to turn around, the accommodation of school bus pickup at the site, to provide safety for pedestrians, bicycles, and motor vehicles. The applicant shall comply with the most recent edition of the National Fire Prevention Association Code and obtain the written approval of the Milton Fire Department and provide for pedestrian accommodation and parking area and lighting throughout the site. I mean, the other issue with the access road, it had 2 or 3 uses. It was providing access to fire vehicles, it was providing access to the parking lot, it was providing access to emergency vehicles, but they also were putting pedestrians on that access road. And we never really got an adequate answer as to why we couldn't accommodate pedestrians on the site. I think the answer is it's too dense. So what we have in that parking lot is a mixture of pedestrians and vehicles constantly. And the concern I had expressed is because some of those are going to be children, it's just not safe. There's a theme here on pedestrian accommodation on the site, which I think was woefully inadequate, regardless of the width of the driveway up the hill. They didn't have any sidewalks when you got to the site anyway, either. And while there were crosswalks, the crosswalks were through the parking lot, and one of the variance requirements or requests was to waive the requirement that the town does not permit pedestrian movements within parking areas. And there's a reason for that. And with such a dense area, I just don't think that that's an appropriate waiver. And since there was no evidence as to why that was necessary, I think that has to be documented. And my thought on that was, in terms of the way the condition would work, that really goes to fire safety and safety in general, and we had some testimony from the fire department. I know it's not perfect, but that's the idea on that. I think the applicant should comply with the lot frontage requirements. You know, this is a non-compliant lot, doesn't have adequate frontage on a public way. And since it owns adjacent property, it seems to me that that's reasonable, particularly given the way that the access works and the condition it creates at the bottom of the hill. I don't think there should be any building construction within the wetland area or within 25 feet of the non-disturbance zone created by the bylaw.
Okay, so you want to maintain the Milton,
Yeah.
more strict,
I think you have to.
okay. You don't have to, but
I-
that's what
I-
you're
Yeah,
proposing.
well, you know, and I also have a condition in here that says that I think the site needs to be more consistent and comply with the Commonwealth Sustainable Development Principles. There was a fair bit of testimony on that. I think the record's been clear that we've been concerned about the representations made as to whether it does, but given the fact that it's a greenfield site and is being built in a wetland, I think there needs to be a condition specifically about limitations on the wetland areas, that no building shall be erected within any wetland area or within the disturbance zone, and there should be documentation demonstrating that the proposed stormwater system has been designed to accommodate the runoff from properties up gradient of the site, that they won't cause flooding on any adjacent properties, and we should address increases in stormwater volume that don't impact adjacent lands. So,
There was a lot made, Jeffrey, of having the storm water running under the buildings as
Yeah.
they proposed. Does your condition relate to that, or do you think that's getting too specific?
well,
Because if
On that,
if you go to a lesser number of units, you may be able to
Yeah.
accomplish that objective by keeping the stormwater
So-
away from the foundation.
I agree. So I'm not an expert in environmental law. I know Marilyn is here, and she is. It seemed to me that our rules required that we comply with the Massachusetts Stormwater Policy Handbook Manual. I think it's a handbook now. And I think that requires that no stormwater be held underneath the site or within 20 feet of a building. So with that, I think the simple condition should be the applicant should comply with our own requirements, the rules for comprehensive permits, which I don't think the applicant did, the application did, and that would be one way to address that.
Okay.
Let's see. Did I say that? Okay. So I had this other condition. To avoid deforestation of mature wooded area, we had that in the application, wildlife habitat, minimize impacts to the wetlands, mitigate view and noise impacts to abutters, reduce the amount of impervious cover on the site, make the project more consistent with the Commonwealth Sustainable Development Principles, and render the project more consistent with the character of the neighborhood. The development footprint should be reduced, and the building should be broken up in a series of smaller buildings. That's a design guideline, I understand, but I do think that it accomplishes several of the objectives that go to the local concern and is consistent with the alternative proposal that we saw. Whether or not that's achievable, I think will be a subject of the site plan that would be submitted for review. So in other words, that would go, that's a little bit different than overall density. It's more about how that density is manifested. I suppose you could cluster the site, but the site is challenging given the fact that a large amount of it is wet and most of it is steep, as you noted on the
As I know
sidewalk.
very well, I
Yeah.
felt like I was a mountain goat after coming.
I think it was a
back
billy
from-
goat, you
A
said.
billy goat. Maybe I should be doing more step masters or something. But I found the site more challenging than was described in the application. Maybe we were just on the more steep topographic difficulties of the site, but I didn't find the site easy to negotiate. But obviously, once a project is built there, presumably that'll be taken into consideration.
So when we spoke on Monday, I had an issue with the width of the site and the kind of the site driveway, if you will, the sustainable development principles, the transportation, and the things that we didn't hear. I think I spoke a little bit about that. On the traffic impacts, I'm still concerned that there's no evidence that you can exit that site safely with a right. And I know that it was a long number of meetings before the applicant agreed to change it to limit to the rights only out. I'd like to talk about whether or not that should be part of the conditions. And there are issues with that because there's no evidence that that won't result on impacts to Reed Street, Wollaston Golf Course, Mark Lane, Heather Lane, Hillside, et cetera, given that people will be seeking to either immediately turn around and head north or figure out the quickest way back to town. And by town, I mean Boston. But there's also no evidence that that of the right density can get out of the site safely to exit the traffic in that AM peak hour, or AM peak hours. So I think there's been a big issue for me. Mostly because of the police department's testimony and the number of fatals that are on Randolph Avenue. I think it's probably the most unsafe condition that's in this application, given the fact that it manifests the safety externally. In other words, it puts other people in danger. And the remedy of calming Randolph Avenue is probably a fabulous one, but it will cause traffic jams that will be unacceptable. So I really like the idea of dropping a lane in both directions. That came up at the end, but that came up from the applicant. But I don't think that works either. So to me, the solution is to limit the exits to the rights until it can be demonstrated that it can be safely done, and the police chief, or maybe the Milton Traffic Commission signs off on that. But I also think there needs to be, it's not just getting across, it's also satisfying ourselves that there's no resulting impact on Reed, Wollaston, Mark Lane, Heather Drive, Hillside. I don't mean to leave out Highland, and I understand the Highland, and people take a right on Reed and a right on Highland, and then they go down and take a right on Martin or any of those ladder streets, so-called. So there are Clifton. I don't want to create a condition that causes an impact in another neighborhood is the point. And there's been no evidence that the right out will be able to be addressed. But I think having the right out is a safer condition than permitting the straight out and permit a left out in the AM. I don't think the problem is as exacerbated in the PM at a lower density. I also think that you start to get into some pretty difficult conditions because I think the chances of widening Randolph Avenue are very slim. And I don't see how you can sneak a lane in, a slip lane into that northbound direction, as desirable as that might be. So I would propose that as a condition.
Mrs. King,
Or at
do
least
you
for
want to be heard
consideration.
on that particular condition?
On the,
The right-hand turn, condition no left-hand turn, 7 to 9 in the morning.
7 to 9 in the morning.
AM peak.
AM, yeah, well, okay, AM peak.
I'm very concerned about the traffic going into other neighborhoods. So, depending upon what we think is going to be the amount of traffic coming out in the morning, I almost think in some ways people could choose to make a right on their own, but if they choose to make a left, it could take a lot of the traffic off of those ladder streets. Is it the safest thing to do? I don't know,
Yeah.
because I see a lot of traffic going down those ladder streets with all the children. I see people trying to make a left-hand turn that might not be as safe as making a left-hand turn, not as safe as a right-hand turn. But I also see people making U-turns.
Yeah,
I see them, turning into Ridgewood, Nahanton, and Sassamon. So I think there's a lot of extra miles driven because of that, and I'm not sure that creating more miles to drive is the safest way to go either. So my thought is there needs to be 2 lanes coming out no matter what. So if people want to wait patiently to find a safe gap, they can. But if people do want to slip around, I guess that kind of divides the number of cars that would be on any particular way, and maybe that's better as a whole. It's a tough one to call.
well, it's tricky because, I've already asked for a wider neck at the bottom of the hill to accommodate the school bus. Or not the school bus, the school bus waiting area, if you will.
Sure.
You're going to have people down at the bottom of the hill. If it wasn't a hill, it wouldn't be as many issues. And it was a hill over a culvert, right? So this is a tricky situation. And by adding another lane, one of the things that the write-out does is it eliminates the need for the stacker because it gets people out more quickly because there aren't as many people traveling southbound in the morning. I understand, Gene, and I agree, it's a bad situation, but it had to have been documented anyway. So what my thought was, it has to be a traffic study indicating appropriate measures are being taken to address resulting impacts in the neighborhoods. So, but I agree, it's all part of the balancing test. It just it shows you how difficult the site is to work with, and maybe in part how difficult it has been to develop that site to date. A lot of it's going to depend on what that volume is. But you'd really have to make the road, I think, wider and maybe accommodate 4 lanes of traffic if you were to provide a stacking lane. I think so.
Well, I'm thinking we can get by with 3, actually, to be honest with you.
Yeah.
And because it's
Well,
going to be
where would the people wait with the school bus?
that, I don't know.
Yeah,
I don't know.
yeah.
We had thought about a
I'm
left-hand.
sorry.
Oh, sorry.
So we got to be very careful here.
Yeah, no.
Because we're not taking evidence or suggestions from Mr. Cram. So I
Okay.
appreciate your ideas. You probably have great ideas, but I
mean,
think we shouldn't go there.
having 2 lanes coming out, not 2 lanes going in, just the
Yeah,
one.
I get that.
is-
Asymmetrical, that's
And
fine.
because it's, you're coming to a stop, because you're certainly going slow, because you're going to turn one way or the other. I don't think they perhaps need to be as wide as the rest of the road would be. I don't know what the actual limitations are on a lane.
These were about 9 feet, 10 feet.
My understanding is there would be room to accommodate that after the wetlands on that ridge where the houses are built, at least for a couple of car lengths or more.
You want me to say something?
Yeah, go ahead.
My view of this is there are no perfect answers. I think what you have to do, first of all, is I agree, even the applicant agrees, that taking a left-hand turn is a precarious business out there during 7 to 9. And so the applicant has proposed having no left turns. We're not the traffic commission, and
I
we're
think
not-
it's 6.
6.
Well,
What do you mean, 6 to 9? What are you talking about?
I mean, people get up early, John.
No, I don't, but
I know you don't.
maybe I used to. But it may be 6 to 9, but whatever it is, taking a left-hand turn with the 4 lanes of traffic is crazy, and it makes no sense. And if we can't impose that condition, then good, let somebody higher than us say we can't impose it, and let them attend the funerals of the people who get killed out there, because they will get killed. I think on the right-hand turn, which makes eminent sense from a public safety standpoint, which I think has to be a priority here, it's necessarily going to produce traffic on those side streets. But you have to look at what we're doing here. This project is to increase affordable housing in Milton. And is it beneficial to the town to increase it to 35, 40 units, whatever we vote, knowing that it's going to increase side street traffic and it's going to maybe upset some people on those side streets? what are the needs of the community versus somebody having to spend another 5 minutes or 10 minutes to try to go to some other street and turn around. I don't, while I love people on the side streets, I think affordable housing trumps that card. And so I agree with you, that should be right turn only, and I understand that's going to cause traffic conditions, but any 40-unit development is going to change the traffic patterns. I know you have to look at it in the context of Randolph Avenue, and I won't get involved with the colorful language that we've heard regarding Randolph Avenue, but you take that as a given, and you say the primary benefit to the town here is to increase the housing, the affordable housing stock, and let the police department, let the traffic commission, other people in town who have greater minds than we do, deal with that issue and deal with those traffic patterns. That's how I'd tend to resolve this. I do think, as Ginny suggested, you need to have slip lanes to allow vehicles to, if they do want to try to make a left-hand turn, to make that right-hand turn, but have a lane there. I think you've got to have some area at the beginning of that driveway for cars waiting, with children, waiting for the school bus.
Yeah.
Now, they've told us that the school bus, which I'm going to sort of transition just very briefly into this other issue, doesn't go onto private property. Well, it should go onto private property. Maybe they don't want to go onto private property. But from my perspective as a layman, it is insanity to have a school bus at 7, 8 o'clock in the morning stop in front of that driveway, whether it's for 2 minutes or 5 minutes, picking up school children, having the children run down and get into the bus. To me, that's a serious safety risk. And I know if we ask the applicant to allow the school bus to go onto the access road for the purposes of picking up and loading children, that would not be a major issue. I mean, the applicant wants to protect children. They don't want children anywhere near Randolph Avenue. And I agree that if the school bus can't turn around because they're big school buses or the drivers aren't the best or whatever it may be, and they have to drive up the access road and turn around and come back down the access road, I say hooray for public safety, and too bad that it takes another 3 minutes to go up there and come back. So, my view of that is, unless I was convinced that and I haven't heard it from the applicant, that they would bar school children or the school bus from coming onto the site, which I guess is insurable if you have to get involved in that type of nitty-gritty. I would try to have that happen here, because I'm more concerned, I think, about the school bus stopping at early in the morning on that road and having children board and exit, whether it's in good weather or bad weather, and whether the people on the side streets are going to have more traffic than they want. You want to address that, Jeff?
Two different issues, right?
They are two different issues. But in a sense, they tie into that same issue of how do you accommodate public safety with the traffic conditions on Randolph Avenue. And if you want affordable housing on this site, you're going to have to make compromises. And none of them are going to be perfect. But you just have to err on the side, in my view, of public safety, the safety of the school children. And if drivers have to spend 5 minutes turning around on the side streets or using a different route, or if the road is a little more congested, the access road is a little more congested because the school bus is there, that's a price that I would be willing to pay to have a reasonable number of affordable housing units on this site. Mr. Meyer.
If the school buses are not permitted to go onto the site, if the school department decides they're not going to go onto the site, would you agree to a condition that accommodation needs to be made for people to wait with their children at the bottom of the hill?
Absolutely. Absolutely.
Well, then I'd be fine with that. That would greatly simplify the driveway, which is one of the most, it's a pretty complicated element of this project, and it's been a big issue for us. So I'm good with that, if that's what you want to do. And then it is what it is. I mean, if the school buses can go on the on the traffic exiting the site limited to rights, I strongly support that. And if it's the board's pleasure to not require a further traffic study indicating that appropriate measures are being taken to address the resultant impact on the neighboring streets, I'd be okay with that if that's where you're
Well,
going.
yeah, my view is we've had enough traffic studies.
No, I know, but
We'll
not
have
on this
traffic
issue.
studies, they'll be able to own the project. They've done so many studies here. I think it's self-evident. You don't.
in the traffic
Y-
business.
I know you do, and you know more about traffic and entering and accessing sites in difficult situations than I do. But I think it is just, it's intuitive that if more people are taking right-hand turns out there in the morning to get to work, the side streets, and you named them better than I did, they are going to be adversely affected. But sometimes you have to pay a price for being adversely affected.
I agree.
And it depends on how substantially adversely they're affected. And I'm very confident to leave that in the hands of Chief Wells and the Traffic Commission. I think that the school department didn't seem overly concerned about stopping the school bus right on Randolph Avenue there and stopping traffic.
That's what it does now.
Yeah, it does, but it's for one person at one driveway as opposed to 15 kids or 20 kids or in the wintertime. But maybe I'm making too much of it. Maybe I'm just I'm seeing ghosts where they don't appear. But it seems to me with everybody in their frenetic attempt to get to work as quickly as they can, if you have a school bus parked out there and traffic has to stop both ways, it just seems to me to be not the best way to do it. But as I say, that's not my area of expertise. What do you say, Mr. Mullen, about the school bus?
Well, I was going to ask you on that. What about the requirement for a looped road?
Oh, yeah, I think there
think
should be a
that's incredibly
requirement for a loop
important.
road. But from my view, absent of doing a design, and I'm not a designer, I think it would be much easier for the applicant to do a looped road with 35 or 40 units as opposed to 92 units.
Yeah, okay. Well, on the school buses, I don't think you have to say anything about the school buses, except that if they don't go on the site, you'll make, the applicant would make accommodations for people to wait at the bottom of the hill to accommodate the school bus. You know what I mean?
Well, you could put that as part of a condition
Yeah.
for the driveway.
Yeah,
Is
yeah,
that what you mean?
yeah.
Okay, and if the school bus, if the applicant would permit the school bus to pull onto the property, I think that would be the preferred way to do it, but presumably we don't have
Both
the,
parties agree to that.
yeah, we don't have the right to
Yeah, right.
require the applicant to do that. But, I mean, that's something I think that any applicant in good faith can work out dealing with the town.
Okay.
My insular view is that school bus stopped out there in the middle of winter with everyone trying to get to work is crazy, but that's, what do you say about the access, the secondary means of access, Mr. Mullen? Do you think if the project goes to 35 or 40 units, that should be a condition?
No.
You wanna-
No, because I had earlier said that they need to get the approval of the fire department for the access. And I think most of those access issues go to fire. At that density, I think everyone would love to have a secondary access, but the secondary access, it seemed to me, required the acquisition of land from the town of Milton.
Or an easement or some type of a license agreement
Yeah.
to traverse the town yard in the instance of an emergency. My guess is, Jeff, and you correct me here, that if there's a public emergency, such as a fire or whatever, the entrance road is blocked, the fire department, the police department have the right to go onto not only the town land, but they have the right to go onto private property
Sure.
in order
I
to
don't think they can
protect
get
the
up there.
public safety. Well, that's right. I'm
They
not
can't get
sure
up
there. Road there.
there wouldn't be.
Yeah. Well, I know there's a lot of testimony on the secondary access. I just thought that maybe it was too difficult to accomplish. If you had a secondary access, I think a lot
Well, it
of
hasn't
these,
been able to be accomplished for a 90-unit development.
lot of these
where
issues would go
Where
away.
it's absolutely, in my view, absolutely necessary. So if the applicant hasn't been able to get a license or a permit from the town for a secondary access for 90 units, my guess is it's unlikely they'd get a secondary access for 35 or 40.
Yeah.
An easement requires a town meeting vote.
Yeah, you got a 30B issue too, I think. You know, it'd be a disposition of an interest in land.
Sure. Ms. King, do
Well,
you want to
I'm
discuss
also
the
thinking that if we
secondary
have
access?
a looped road, I see the need for having a secondary access not nearly as high.
I agree with
I don't think we're going to have that kind of congestion that the fire chief had talked about with the 90 units. So I don't think that we really do need to worry about that.
All righty. Mr. Mullen, do you have any other
I think,
conditions you want to discuss?
I think we should require the applicant to obtain any necessary state permits, including MEPR if necessary. I don't know if you need that. The only other thing I wrote down here, John and Ginny, was the snow storage issues, but I wondered if those don't be incorporated within the site plan review, and that's really a detail. I know we got into the detail on snow storage, and perhaps that's something the planning board gets into all the time, but I thought that was driven just by the compressed nature of the site more than anything else.
It was.
One of the reasons why I raised snow storage is there was testimony about the owner of 11 Reed Street, whose name I'm forgetting.
Is that Mr. Carlin?
Carlin. He had a concern about that, but to the extent and assuming that snow storage is addressed in the site plan, I don't know that we need a condition on that, unless the board wanted it. But
Well, I guess the real issue is not, to my mind, is not where snow storage would be, but to ensure that snow storage, if it's going to be on site, doesn't adversely affect the wetlands or doesn't impinge
yeah, I agree with that.
on the
Or
wetlands.
the neighbors.
Or the neighbors, sure, or the neighbors. But I tend to think that's easily accomplished. But if it's not, the applicant can certainly come to us, and that can be modified in any reasonable way. You in agreement on that one?
I am. That's really the extent of my concerns.
Mrs. King, do you want to?
In general, or what we were just speaking about?
No, in general.
general?
We've finished that particular condition.
Just go through what I've made notes on this with.
Well, while you're looking at that, let me
Yeah.
mention a couple of things here. My thought was, and my memory is, that the applicant agreed to put a second hydrant on the site. I'm not technically sure whether that would be required under the fire chief's determination with 35 or 40 units, but I don't see that as an additional, an expensive issue. And so that's something maybe, do we want to discuss that, or is that, it was a major issue if there were 90 units. I honestly don't know whether it's a major issue with
Well,
with 40 units, 35 or 40 units. I
if
mean,
we agree to the condition that I read, you'd have to get the fire department's specific approval.
Okay. Let me see if you want to address the issue of the parking spaces that are on the so-called Paul Kingston easement area. The board did receive a letter from Diane Tillotson, I think, of Hemingway and Bonds in Boston, representing Mr. Kingston, and she indicated that while the applicant had removed construction buildings or foundations from that easement area, they were still seeking to have 20 parking spaces there. And she objected to that on the basis that that would be a violation of the the terms of the easement that Mr. Kingston had granted, and the applicant secured an opinion letter from an attorney that I don't have at hand. And his opinion was that that would not be offensive to the easement, and Ms. Tillotson thought it would be. So do you want to address that, Mr. Mullen?
I don't know.
Well, it's kind of a confusing and difficult issue because the applicant is saying, well, this isn't a commercial venture, therefore the easement doesn't apply. Ms. Tillotson's argument, and I'm going to simplify it because she's a very, very bright lawyer in the zoning in eminent domain area. She says, well, yes, they may be using it for a residential development, which is not, which is being used to house people and people who need affordable housing. But in essence, this is a commercial project when you look at it overall, and there's some type of either parking charge or it's factored into the rent, and so she thinks that that is a violation of the restriction on the easement that's presently on the property. I don't know whether that's going to be an issue if you go to 35 or 40 units. It may not be. Maybe they don't. We didn't discuss parking, but how many parking spaces, I guess, do you need if you're dealing with half the units? And maybe that area, just by the applicant's own revised plans, would back off of that area, and it wouldn't even be an issue. But,
I think we need to honor that easement. Commercial apartment buildings are insured as commercial ventures. It is a commercial venture. I realize people are living in it. People live in hotels for an amount of time, but they are commercial ventures. I think that with a smaller number of units, it is possible to avoid that area. There was, there was no point in the whole deeding and easement of that land if we don't consider this to be a, and that would mean that, land was purchased for something far less than it should have been, and I think it really will hold up in court as a commercial venture.
okay, so you want
I
a
want that-
condition requiring the applicant not to park on that Kingston land. You in agreement with that, Mr. Mullen?
Well, another way to do it would be to obligate the applicant to comply with land use restrictions on the site and not take a position on the enforceability. I mean, there's a difference.
Well, there is a difference, but the problem being that just leaves the situation indefinite, so that Mr. Kingston has to spend a fortune. I shouldn't say that, but spend a lot of money on lawyers to litigate that issue. On the other hand, if the applicant believed that their expert's opinion was the better opinion, then they'd have to spend a lot of money on litigating that issue, whether it's in the land court or not. Maybe everyone will end up litigating it anyway, but I would prefer to deal with it here and now, and if people disagree with our judgment, they certainly have the right to protect their legal rights. My hope would be that issue would go away, that it's not
In the design.
in the design, that it wouldn't be necessary to do that. So why create issues that are going to cost a lot of money and not unless they're critical to the project? And
Okay.
if the applicant thinks they are critical, then he's got his perfect right to seek a declaratory judgment as to what that easement really means. Okay. Now, Mrs. King, do you want to deal with any additional issues? Because I stopped you while you were reading your notes.
Where was I? We haven't talked about the buffer zones, not buffer zones, but screening zones around the property. And I would like to add that we do have something that's buffering, because this is a piece of a zone that's going to look very different from the rest of the zone, and I believe that vegetative buffering needs to be there.
within any particular number of feet from the lot lines?
Well, depending upon the density of that buffering, I'm thinking in the at least 25-foot range.
Mr. Mullen, do you want to be heard on that?
I thought that was a site plan issue, but I'm happy to discuss that. You know, I thought we had captured the setbacks, but we didn't really. I mean, it was just something that I thought would be addressed in site plan review, but
It may very
Jenny
well
makes
be.
a good point.
It may very well be.
Well, part of my thought on this is that we are, by putting in conditions, we're giving the applicant an idea of what would fly through if another design comes before the board or comes to the town. And so I think that the direction that we can give that's going to help our neighborhoods, it's going to help the residents of this development, what's going to help the residents of that neighborhood, I think that's going to be helpful for the applicant to know how to go forward. And, you know, he knows what we don't like, but maybe we should give a little bit more idea of what we do like.
Yeah. Well, there is currently setback requirements, right? It's in Residence C, isn't it?
Yes.
Residence C and Residence A, I guess it's in both.
Well, this would be more of a vegetative thing as opposed to just.
I'm sorry.
just,
I'm sorry. You're not
the
talking about
building.
setbacks. You're talking about I see.
Yeah.
Well, right, and one thing that impressed me when we were on the site view, when we got up
Yeah,
to the
there's no
top of the
border.
mountain
There's
there,
no border.
when you looked at Mr. Collins'
That's a fair
property,
point.
you remember Mr. Collins' property there?
Yeah, yeah.
My recollection was that there was parking proposed, and I think that parking was like 20, 25 feet off of Mr. Collins' lot line.
Yeah.
And
Yeah.
we noted the close, now maybe that
Fair enough.
can be redesigned if you're using a lesser number of units, so you're not going to directly impinge on Mr. Collins' backyard. But if you assume, and we can discuss that, how specifically to deal with that. But if we don't deal with it specifically, then you certainly have to provide some type of vegetative buffer. Otherwise, he has no backyard.
Yeah.
He'll have cars almost in his backyard, and the lights will be as if there was some type of a stadium next to his property. And he has a big, beautiful house there. And I think his property may be in a Residence A zone. You may know that better than
I
me.
think it is in here.
I think it is, yeah.
Okay.
And
Wh-
it's
wh-
also.
what is your wisdom?
It's also in a place where the Carlin house is significantly lower than the bulk of the land in question here, and so that could bring in the whole idea of, you know, headlights going into bedroom windows and so forth. You know, if it comes into my first floor, I don't like it. If it comes into my second floor, I'm really hating it, and I feel that that's excessive. So I think some buffering so that those sorts of things don't happen would be a necessary condition.
What's the width?
I'm sorry, the width?
We're talking about a landscape buffer area.
Yes, you mean the well, Virginia's suggested 25 feet. I'm looking at some conditions here from Attorney Schneider, and she is suggesting 50 feet. A 50-foot vegetative buffer between the development and any adjacent property lines.
I was
50 in the,
I'm sorry?
I put 50 in the draft.
I was thinking that 25 would be a minimum, but it might be necessary
Well,
to have more.
look at my view is that if there's any possible impingement on somebody's single-family residence in a Residence A district, I'd make it 50 feet to
I'm fine with
give
that.
that resident the benefit of the doubt.
I'm fine
What do you
with
say,
that.
Mr. Mullen? 25 feet or 50 feet?
I want to know what we're talking about. We're talking
We're
about a
talking about-
landscape buffer that's 20,
Yes.
that's 50 feet wide along every
50
edge
feet,
of the site?
50 feet from, yes.
Just
Well,
nearby
from
residents?
nearby residences, you couldn't buffer the entire site, but from nearby residences.
except in the wetlands.
The residents of frogs or
No.
tadpoles? Or?
A fair bit of that would be in the wetlands.
Let's on the southerly and westerly property line,
Yeah.
the board can't do anything in the back.
Yeah, I think that's right.
So that's along Carlin and Mullins in the
Yes.
back there.
And Lombardi.
And
Lombardi. Kingston.
Mr. Kingston, yes.
Well, it is a Residence A. Okay.
And we had already included about stormwater,
We did.
ensuring that that doesn't run off.
Yep, we did.
Okay.
You in agreement with 50 feet, Mr. Mullen?
Yeah.
Okay. Let me just ask another question, and this is something that it may be dealing in issues which we don't have to. We had the chief testify that he thought that the access road should be lighted.
Yeah, I have that.
And the parking areas should be unobtrusively lighted in some safe way where crime is deterred, and yet light doesn't emanate from the parking lots onto nearby residences. Now, is that something that you believe is the subject of a condition, or is it something that should be handled more generally? If you want to
Well, in
handle
the
it more...
condition that I read, it included parking, it included lighting, pedestrian accommodation and
Did it specifically say lighting? I don't remember.
yeah,
which-
lighting
okay,
throughout the
okay.
site.
Okay, great.
But I didn't get into the type of lighting.
And then and I don't think we should,
Yeah.
because we're not
That-
lighting a
So on the
contract.
lighting, I was a little confused on the lighting with the application. I think it was part of the waiver of the bylaw was part of the original application, but then I think it may have dropped out in the secondary round because I didn't see it in the later application. So the way I interpreted that was the applicant had actually incorporated lighting in the parking areas as part of the program. I don't know if that's true, but I think that's what happened.
It's my
There
recollection.
wasn't any real testimony on that, I don't think.
It's my recollection that Mr. Burke, in one of his
Yeah.
supplemental filings, addressed the issue of lighting. I just don't remember
Yeah.
how
yeah.
specifically he was.
So I didn't think that the parking area lighting was really an issue in this application, to the extent that the board wants to say something about non-obtrusive. I don't object. I'm not sure it's necessary.
Okay.
You know?
Mrs. King, do you have any other issues you want to discuss?
No, I think that just about covers what I was concerned about.
Mr. Mullen?
Nope. I'm sorry, no.
Okay. I don't think I do either. I guess, I think certainly the major issues we've discussed and I think have dealt with.
We need to talk about parking spaces and units.
Right. But I wonder whether that's, obviously they have to comply with the bylaw for parking. But do you think is that a significant issue if the project consists of 35 or 40 units?
Still have to state the number.
Yeah, I guess.
Remind me now what we need to deliver for each unit.
Well, I thought
1.5,
the
is that it?
bylaw was 1, 2. You say 2?
Two?
I think it's 1.5.
That was 1.5.
I could be
yeah.
wrong.
The,
Well, if they have to comply with the bylaw, and they do, then whatever the bylaw says is the parking that's required, and they have to follow. But I don't think that the placement of the parking is as significant with talented engineers if you're using
Right,
a
right.
much smaller project. You want to address parking, Mr. Mullen?
No, I didn't want to, actually.
Okay.
I
I just think we should comply with the bylaw with respect to parking for the number of units that we vote.
yes.
Okay. I don't disagree with that. Okay, do you have anything else you want to say, Mr. Mullen?
No.
Mrs. King? Okay, let's talk about density and the number of units. Where do you stand on the number of units that we should vote?
Right where I was an hour and a half ago at 35
You
only.
say 35.
Well, for the same reasons I think you said when you were talking before, and that is that's the subject of the Reamer and Bronstein submittal, and the representation's been made that that's affordable. That it's not affordable, I'm sorry.
Feasible.
I agree.
It's feasible.
Economically feasible.
That way, we're not picking something out of the air.
A little
This
reluctant.
is what's been given to us is some variety of evidence, and I think that would be the way to go.
Okay, the other issue is Mr. Lombardi has suggested 40 units, but he hasn't provided any real details.
And I
on
wish
that.
he did, and I agree with you, John. I mean to interrupt you, but I agree
you're
with
not
you. I wish we had much more testimony on many of the things that I think that I thought we were going to hear about, and we didn't. But we didn't, so we have to deal with it, and that's unfortunate. But I'm concerned that you run the risk of being somewhat random if you don't adhere to that standard. So.
We picked it for a good reason. You know, that's the best reason that we can come up with.
Okay. All those in favor of granting a comprehensive permit to allow the applicant 35 units on the subject property with the statutory requisite amount of affordable units as part of that 35 units, together with the conditions which we've all discussed and agreed upon this evening, please say aye.
Can I
Ginny, yes.
ask one question
Sure.
first?
Of course you can.
Are we looking to have this in a village style, which would be more than one building?
Well, I had that in one of the conditions I read about breaking up by creating a series of smaller buildings.
Okay,
But
so
I-
we're including that.
Yeah, and
I didn't use the term village.
Okay,
no, but you can.
but you've
Good, I
defined
just
it, which
didn't.
is better than village, actually.
Yeah.
Yeah, that's fine.
Yeah, but I think that's what we certainly intend. We're not imposing design requirements.
No.
But it's the
You don't-
nature of the,
I think it's fair to say that the board's concerned that one of the buildings is the size of a football field, and that's inconsistent with and sounds in the local concerns about which we've expressed concern a couple of times. So the idea on reducing the massing of the buildings by breaking them up into a series of smaller units is, something for the site plan review, I think, but how that gets done, I don't know.
I had left it very vague to say that it was however many, one or more buildings, which the applicant could show on a new set of plans that he submits on page 5. So.
okay. All right. So let's go back to our vote. And let me just, before we do vote on it, Mr. Cram, you've reached your final decision that you do not want to file a proposed set of findings. Is that still true after our deliberations?
I don't think that's what I've said, but that's fine, thank you.
Okay. So all those in favor of granting the applicant a comprehensive permit for 35 buildings?
Yep.
35 units.
35 units, excuse me, thank you. 35 units with conditions as we've discussed and agreed upon this evening. Please say aye.
Yes.
Aye.
Okay, aye. So we have a unanimous vote, and let me thank everybody for attending, and thank you for your comments and your zeal. And we'll have a decision for you within 14 days, and everyone can read the decision and protect your own interests as you see they may be. But thank you for coming and participating.
Thank you, Mr. Chairman.
Thank you,
Board.
thank you, and give our best to Mr. Caggiano. Okay, we're adjourned.